Hi, everyone. I'm Mark Jameson. I'm a visiting scholar at the American Enterprise Institute, working on technology and telecommunications issues. On October 6th, the House Judiciary Committee's Antitrust Subcommittee released a majority staff report on the subcommittee's, as it describes it, quote, more than 16-month investigation into the state of competition in the digital economy, especially the challenges presented by the dominance of Apple, Amazon, Google, and Facebook and their business practices, close quote. The report's more than 400 pages long and has received both great adulations and great criticisms. I think it's fair to describe the report because it describes itself this way as an attack on how America has approached antitrust for the past 40 years, which has emphasized consumer impacts and the coldly analytical techniques, although not without some occasional political flair. We're here to consider the majority staff report, its foundations, and its implications. To help us with this, we have three impressive panelists that are experts in this field. And let me make introductions of them now. First, I'll introduce Tom Hazlett. He's the H.H. Macaulay Endowed Professor of Economics at Clemson University, where he researches law and economics while specializing in the information economy, specifically regulation in telecommunications, media, and the internet. He previously served as the chief economist for the Federal Communications Commission and has provided expert testimony in federal and state courts, regulatory agencies, congressional committees, and foreign governments and international organizations. His latest book, The Political Spectrum, The Tumultuous Liberation of Wireless Technology from Herbert Hoover to the Smartphone, was published in 2017. I've read the book. It's an excellent read. The second panelist will be Maureen Olhausen. She chairs the Global Antitrust and Competition Practice at Baker Botts LLP, where she focuses on antitrust, privacy, data security, and consumer protection. Maureen's has most recently led the Federal Trade Commission as acting chairman and commissioner, where she directed all aspects of the FTC's antitrust work. She led the U.S. delegation in international antitrust and data privacy meetings and was recognized for her knowledge and contributions at the commission with I think it's the only time it's been done for an FTC commissioner to receive the Robert Pitofsky Lifetime Achievement Award. Prior to her role as a commissioner, she led the FTC's Internet Access Task Force. Our third panelist is Danny Sokol. He's a professor of law at the University of Florida's Levin College of Law, where he focuses on corporate governance, innovation, mergers and acquisitions, and business regulation. He's a co-editor of the Oxford Handbook on International Antitrust Economics, 2 volumes, as well as the Global Antitrust Compliance Handbook. He's among the top 10 most cited antitrust law professors in the past 5 years, and in 2014, he was the first non-PhD economist to be named Antitrust Academic of the Year by the Global Competition Review. Danny has also testified and presented his work to authorities in the US and around the world. So thank you to all three of the panelists for being here, an impressive group. So here's how we'll proceed. I'll ask the panelists questions until about 1:45 p.m. Then we'll take questions from the audience for about 15 minutes. We'll end at 2 p.m. Please, anytime during our discussion, submit questions. And there are 2 ways to submit them. You can submit them by emailing them to William Rao, and that's William, WILLIAM .RAU @aei.org. Again, it's william.rao@aei.org. Or you can send them to us on Twitter at #AskAEITech. Again, that's #AskAEITech. Right, so panelists, let's just jump right into it. Maureen, I'd like to ask you the first question. So this report, as I said earlier, is not 4,000, as I almost said, but 400 pages long. 375 of those pages are the criticisms of big tech. 25 pages of ideas on how to break them up or regulate them. Let's talk about that 375 pages. What does it not say that'd be really important to know about big tech?
Well, Mark, thanks so much for having me, and to AEI for hosting this. I'm delighted to be on this panel with my good friend Danny, and look forward to hearing Tom's views as well. It is kind of funny to think about with such a big, long 375-page report to focus on what's not in there. But I think it's very important to understand that antitrust law is generally, in the modern era, focused on consumer interests. What is the impact on consumers, on price, on quality, on variety? A whole host of factors that consumers value. And one thing that struck me as I read the report is it's not talking very much about consumers and consumer interests. It focuses quite a bit on the idea that one, business entity or competitor or potential competitor didn't like, some particular outcome in the relationship. There might be, a vertical relationship and they, wished it was fuller or smaller, it had some different terms, but very little discussion back to consumer interests in variety and innovation and in quality. Just very passing references to that. I think some of the other things that are missing from the report is an even-handed approach to the fact that, for example, there's discussion by focus on a study by one professor who said that merger remedies had been ineffective. Well, there is very serious criticism of that study as not being representative, of not being a robust study, and that never appears in there. So you would think that that was the only viewpoint. So those are some of the things that I see. And when you think about antitrust, one of the strong trends in antitrust driven by economics and understanding of economics is the rule of reason approach. Right? It's not a per se approach. You did A, so therefore, it's an antitrust violation. That's been limited now to a very small class of behaviors where we are fairly confident that they will be bad for consumers. They, price fixing, market division, things like that. But here, the whole rule of reason approach, the idea that you may have competitive behaviors that may harm some competitors in the market, but they benefit competition overall, or they benefit consumers. Fierce competition, which is something we're supposed to, be willing to tolerate in the free market. I think it gets very much a short shrift. There is the idea that there's not any kind of balancing test. If a company does something and some other player doesn't like the outcome, feels disadvantaged, that seems to be a sufficient grounds for the report to say, oh, there's an antitrust problem, a competition problem here that's not being addressed. So those are the three kinds of issues or factors that aren't included in the report that I would have liked to have seen.
All right. Well, thank you for that. Danny, what would you add that you noticed as missing?
Thank you, Mark. Let me just begin with a series of disclosures. I'm a full-time employee at the University of Florida. That means Florida residents pay my salary, but frankly, those of you who visit Disney World or our beaches also pay my salary. So thank you, everybody, for that. More of that, please, particularly when the pandemic is over. Second, 1 day a week, I am senior advisor at the law firm of White & Case. In that capacity, I do work for a number of platform companies, some of whom are mentioned in the report, others of whom are not directly mentioned in the report. I've done also work for other platforms over the years. And then finally, non-resident academic advisor at the U.S. Chamber of Commerce, where I represent every single company that's a member. So I disclose all of that. So I want to focus my comments very early on the single page out of the 375-page analysis that actually mentions, and this goes to Maureen's point, that platforms may be pro-competitive. 1 out of 375 pages. And given the rather extreme departures from antitrust policy that were bipartisan, going back a full generation, I think the burden that the House report has to show is that consumers are ultimately hurt. And if they're going to do that, they need to really cite to the empirical literature on the platforms. But that's not what we get. Instead, it focuses on news stories, focuses on some testimony from professors, and strangely, the various submissions from professors were never made public. And I understand why, certain complainants wouldn't want their material made public, but the whole point of academic freedom is professors are out there to be public. So I wish they would have done that so we could have actually seen that. Some people did on their own, but again, the more you don't have transparency in a report, the more you don't back it up with evidence, the more it looks like a political document rather than something that's weighty. And I mention this because if we say compare this to agency reports on tech, for example, the FTC's big data report, where you had all the submissions and where there was nuance and synthesis of the different positions. This one was very one-sided in what it chose, but in a sense that's okay because we already knew what the report was going to say when there were a series of, there was an email that was sent out by 2 law professors that basically said what the report would say long before the hearings were concluded, which means the outcome was already determined. The irony here is that outcome determinative reports with facts to fit foregone conclusions is typically what our US antitrust authorities like to rail against when we see this kind of behavior in the rest of the world. Now, to be sure, the House Judiciary Committee is one of 2 chambers of the legislative branch. It is not, it is not an agency itself, but nevertheless, from that standpoint, it's disappointing.
All right, thank you, Danny. Tom, you're at a disadvantage. The other 2 have already talked, but is there anything else that you found missing from the report? Tom, you're muted.
Yeah, thanks. Just to follow up on Danny's comments, I mean, I was asked by the House Judiciary Committee to submit a paper to the proceeding, and I was rather surprised that none of these papers, although they were summarized in terms of telling us what number had been collected from academics, none of them were listed, and didn't. In reading, I didn't see any effort to actually incorporate the diversity of views that that they had in good faith collected, and so that's does look suspiciously political at the end of that process, and there is a criticism that this is a polemical report that does not engage the key substantive issue, and that is that there are important trade-offs, and in fact there has to be a balancing of exactly the sorts of conflict issues that arise with vertically integrated firms or firms with large market share. And these are the 2 primary concerns of the paper. But the paper, of course, is very rich in interesting anecdotes and stories that are developed, which are alleged to be, brimming with implications, but they have no real consideration of the alternatives. They condemn a consumer welfare test where in fact the costs and benefits of a particular antitrust policy or a particular strategy in the market can be assessed. They want to move away from the consumer welfare standard, but have nothing except a vague notion that public interest regulation, sort of an old-fashioned agency regulation, might do better. Well, that would have been a very interesting premise to pursue. And in fact, if you go back to the early days of antitrust, there was the 1890 Sherman Act just after the 1887 Interstate Commerce Commission, or Interstate Commerce Act, that gave us the Interstate Commerce Commission. And that was a public interest standard that has the sort of political consideration of costs and benefits from integration, and allows regulators to make political judgments without any firm standard. And in a word, that was extremely anti-consumer. There's been a lot of work on the price-setting policies of the Interstate Commerce Commission, its impact on innovation, social welfare, the income distribution, and in fact, environmental amenities. And in fact, on every count, the Interstate Commerce Commission was antisocial, and indeed was abolished some 25 years ago by the United States Congress. Now, that is a comparison to what the report vaguely suggests as an alternative, but it's never openly considered. So there really has to be some focus on the consumer welfare standard. Everybody does it, including the critics who, say that we shouldn't just focus narrowly on prices. And, of course, by that we mean quality adjusted prices and outputs in the market. But of course, when talking about whatever it is, say a predatory strategy, everybody wants to say that this kind of strategy harmed consumers. That's the only way you can put sense to that kind of interpretation of competition. Otherwise, any kind of competition between firms becomes harmful to some competitors and is anti-competitive, because it does make things tougher for some participants competing. You want to know at the end of the result, is there something better or worse for consumers? And so that is a very important standard. In fact, I'll just mention this. In 1996, when there was a bipartisan effort, ultimately successful, to rewrite the 34 Communications Act and to replace the old rules with new rules in that sector of the economy, I wrote something arguing that the public interest standard in the Communications Act ought to be jettisoned in favor of a consumer welfare standard to move it closer to what the analysis is in antitrust. And well, it was me against the Congress, and the Congress won. So that was not exactly what happened there. But that debate should be entertained. You want to go with the approach that puts social gains first, as interpreted by consumer welfare and standard models used by economists? Or do you want a vague political standard that can be manipulated for protectionist policies? And you see that those protectionist policies are actually littered throughout the report. I'll just mention one, and that is, much to my surprise, the report speaks favorably of all the public interest outputs during the COVID pandemic by publicly licensed, government licensed private broadcasters, and quote favorably from the National Association of Broadcasters about emergency public interest announcements being made, which, by the way, are not carried to customers in almost any case by the public airways that have been licensed. They come through cable, satellite, and over-the-top broadband, which are, the unregulated sectors that have actually subsumed that sector. And so the old rationale for the licensing policy is given credit for public interest outputs that it rightfully deserves none of. And of course, the cost of having that old system of regulation that does such a good job to suppress innovation and to make things more difficult for efficiency and consumer welfare and innovation goes by the wayside. So this approach to protecting given competitors in the marketplace is a marked feature of the report, which really deserves some criticism.
All right, thank you, Tom. So in a little bit, Tom, I'll ask you to elaborate a little bit more on, if you lift the rigorous standard, what do you think starts happening then? You've already talked about it, but I'll ask you to elaborate a little bit more. Before doing that, though, Danny, something that you talked about had to do with the quality of evidence. And I want to ask you about that. So with the factual basis that the staff lays out, the majority staff lays out, criticizing, how solid do you think that evidence is? And how well do you think the staff interpreted that evidence?
So I'll assume that the staff had all of the evidence. If we look at the empirical literature on online platforms since the year 2000. I arbitrarily say 2000 because that's when I started counting. And we look at all of the journals that, for example, would make the FT 50 or similar rankings for top journals for business schools, whether it's economics or finance, management, information system, et cetera. There are roughly 250 empirical papers dealing with platforms and different types of platforms. Much of the empirical work focusing on the US, but not exclusively. Not a single one of those papers is cited. Now, maybe the staff looked at it, but given that they were willing to find, any number of newspaper articles to cite, presumably, if they wanted to, they would show their work and cite that they had actually looked at those articles. And what those articles generally show is that the results are pro-competitive for platforms in terms of their dynamics and what they offer, and that there's a lot of times the literatures across these fields uses different words, like they'll use the term value creation. In an antitrust context, we might say consumer welfare enhancing, but let's assume that more or less we're talking about the same kinds of terms. That's missing, and that's unfortunate, because the more and the reason I mentioned why this is important is because, again, are there problems with antitrust or indeed any other area of law or regulation? The answer is, of course. We should always be tweaking the system to make sure that we're bringing good cases. And so I'm not one who believes that antitrust enforcement should be limited to just short of actual enforcement. I think government plays an important role. I think private parties play an important role. But when you're advocating change, I'm a professor. If someone makes claims and doesn't show their work, that's not getting an A in one of my classes. And I think, or frankly, I think anybody's class. But I think one of the mistakes of not really going with what the empirical evidence shows is that there's a lot of nuance for how platforms operate. Each of the 4 platforms that are mentioned in the report have very different business models and orchestrates its relationship within its own ecosystem differently. But what we see is when we get to recommendations, a lot of behavior just gets lumped together. And that's unfortunate as well. So we get a very coarse document. And we can compare this, for example, to the last bipartisan report, which was much more significantly footnoted, much more nuanced and textured, and that was the Antitrust Modernization Commission roughly a decade ago, and you see a very different kind of report.
So thank you, Danny. Now, Maureen, I'm going to turn to you on this as well. So Danny talked about the lack, if you will, of kind of a critical view of the information that they had and then how they interpreted it. At the FTC, that was your job almost every day. What was the valid evidence? How do you interpret it? How do you make sense of it and draw a conclusion? What are your thoughts of how this report does in that regard?
So I do think that is one of the challenges here, because while there is a lot of anecdotes and discussions about the behavior of 4 particular companies, and Danny's absolutely right that lots of behaviors that are different are lumped together. But showing the link between that, anecdata is what I would call it for 4 companies, and very sweeping recommendations for policy changes in antitrust. So when I headed the policy office at the FTC, I also headed the program for competition advocacy. And we would, on a bipartisan basis, the commission would vote on it, make recommendations or weigh in on proposals to see whether regulatory proposals would make consumers better off, make competition work better, protect consumers better, things like that. And here, there is not that link to say, well, we're going to take anecdotes about what a particular company has done and then say we should change the presumptions in merger law overall, even well outside of these four companies, that we should change the way companies have to deal with possible rivals, to say they must share their facilities or their IP or what have you, something that a competitor wants to use to get into the market. So I think taking those kinds of particular things and then expanding them out to very sweeping types of proposed changes for antitrust, even the goals of antitrust, right? The multifactorial, I know we're going to talk about that, from really just a handful of examples without looking at, well, what is the likely impact of those, right? Because there's always just for one example, having restrictions, great restrictions on the ability to acquire smaller startup companies. That will have an enormous impact in how R&D and innovation is funded and grown in the US, right? We have a whole ecosystem around small, companies having an idea and getting funding and saying, well, now I'm going to develop this. And one of my exit strategies is I'm going to get bought, right, by a company that then can take it to the next step, to the next level, who can integrate it, who can give it support. There is good research out there on that ecosystem, and it's just not addressed. And I think before you would make a sweeping policy change that could have those kind of follow-on impacts, I would hope for a little better grounding in that type of, like we don't want to be guessing, right? If there's evidence out there on what these impacts are going to be, even if one might come to a different conclusion about whether they're worth it or not, I think you need to at least understand that they're there. Those trade-offs are there.
Yeah, I've been impressed studying literature over the years of how the economics and business strategies of these types of businesses are indeed somewhat different than what we've seen in the past. An excellent book, The Business of Platforms, written by some professors from Harvard and MIT, goes through the complexities and the sensitivities of the business models. Just a small mistake can oftentimes take a company out of business. And some work by a friend of mine at Harvard on how do we actually develop knowledge in these kinds of industries, and acquisitions become an important part of that. But one thing that also struck me that proves true across industries is about 90% of the firms that start up don't make it. Some of them go out of business, some get acquired, but it's a small fraction that actually thrive and get everything together right. So just underscoring some of the things that you and Danny were saying. Tom, let me now turn to you, and so you can pick up part of that question, but I'd really like for you to elaborate on what you were talking about earlier. Because the report suggests this kind of change in direction in antitrust, away from this consumer focus, this kind of well-developed analytical methods that have been created over the years, into something that at least at the moment feels a little bit more amorphous. What do you see happening if we were to go down that road? You're muted again, Tom.
Thanks. I got dogs. I got a 120-pound bull mastiff here. I don't want him to take over the show, so sorry. That's why I'm muting. But yeah. So we have this. Maureen was talking about the rule of reason, which is generally used for antitrust because we do have costs and benefits on both sides. There's a lot of activity that has to do with vertical integration that's very widely, deeply, broadly throughout the economy efficient, and study after study shows this. But there is the possibility for some kind of vertical foreclosure. We want to have some kind of real evidence and nuance under a consumer welfare standard that actually evaluates the trade-offs rather than simply gives us anecdotes of possible harm to competitors. And that's what the report is very long on. And reading it, I kind of got the impression I was back in 2005 and people were talking about Walmart. because in the day, Walmart was extremely controversial for engaging large economies of scale and new technologies and just-in-time inventories, new business models, and really lowering prices across a broad range of competitors and achieving what was impressive scope and some alleged market power. And that attack on Walmart, which was considerable in the political world, often through state and local governments stopping the expansion of Walmart chain stores, that attack really faded, not only when there was overwhelming evidence by some economists that did very good work showing the massive consumer benefits from Walmart and the fact that it had been a more successful income maintenance program than any of the government, far more lucrative for low and middle income Americans than food stamps, for example. Not only was that successful, of course, by the time you got to a decade or decade and a half ago, you had the emergence of e-commerce, which was a fundamental challenge to the bricks and mortar kind of business model. Now, with this report, you get a lot of stories about how tough it is for certain competitors, and reading it, I really did say, well, thank God for courts of law, because these kinds of stories are forms of evidence. But they must be probed. They must be probed in an analytical way. That's why consumer welfare standard is so important. But they may also, they have to be run through to see if they really make sense in terms of the allegation being made. So when you talk about mergers being anti-competitive and predatory tactics of companies like Amazon on their platform, the first thing I notice is that Amazon started as essentially 100% Amazon products. That was what was on their platform. If you go to the late 90s, much more than 95% all Amazon sales. Today, it's less than 40%. They have created an enormously successful platform for third-party vendors. Now, that conflicts frontally. That evidence rejects the idea that schemes are being put in place to undermine these third-party sellers. Now, the third-party sellers had said, well, they don't have any place to go. They've had places to go all the way through. And in fact, when this whole rise to prominence of that platform began and has run its course, you have companies like eBay that run very pure, non-vertically integrated platforms, different business models. Of course, you have other new markets coming up today, including Shopify and many other forms of competition. But Amazon has been successful in attracting those third-party vendors. And when you get to some of the anecdotes about what happens, it turns out that the anecdotes really prove quite the opposite. I'll very briefly mention one of my favorites, which is the alleged predation against diapers.com, which started about 2005, selling baby products on the Amazon platform. Two entrepreneurs who idolized Jeff Bezos and wanted to be Jeff Bezos, they came along and actually launched something that by 2009 was the #1 online seller of these baby products. In 2005, the firm was bought out by Amazon for $540 million. The allegation is that this was the end of a predatory contest against these two entrepreneurs. And in fact, there was about a $400 million capital gain to the investors, including the entrepreneurs. They became part of Amazon for a very short time. Then one of those entrepreneurs peeled off, started his own e-commerce startup, Jet.com. Within a couple more years, sold that for $3.3 billion to Walmart, where today Mark Lohr, formerly founder of Kidsey and Diapers.com, is now the head of e-commerce, competing for Walmart against Amazon. Now, that is certainly not a story of successful predation in the sense that you're gaining a reputation to discourage entry into the market. This was a fabulously successful entry into the market, and there is no evidence presented that in any way consumers were harmed by this. There is some hand waving about, oh, this was less competition. In 2017, the old diapers.com that was bought by Amazon was terminated with some allegations that this. What matters to customers is the range of choice in the market and the prices they pay. And there was no evidence presented that that had in any way been constrained. And in terms of innovation, the innovators were extremely well paid, successful, and now form a model for what others might want to do to compete in that space for or against Amazon.
All right, well, thanks. I appreciate your digging into that. Maureen, you've been in that space before. You had to make decisions based upon kind of the 40 years of tradition. If those kinds of approaches, that policy focus on consumer welfare, the well-developed analytical methods, if had not been there, what do you think the outcomes might have been like? Maybe if that's unfair, just change the question. I'd just like for you to look ahead as well. If we change it, what happens next?
Yeah, that's an excellent point, because having been someone who's had to make these decisions and try to, at the FTC, you have to try to get consensus at least. When I was the chairman, it was only myself and my Democratic colleague, so we had to bring an enforcement action, we had to agree. And we were able to find a lot of common ground. So having, I think, a clear goal for antitrust of consumer welfare was, the foundation for having predictability, for having transparency, for an understanding of why certain decisions were made, and then making those decisions reviewable by courts. Because there's several problems with introducing a very complex, multifactorial kind of balancing test for the ultimate goals of antitrust. So I talked about the balancing test of the rule of reason, but that's all about, ultimately, on balance, is this behavior good for competition and good for consumers? But we know what the goal was, that single goal. It's also a question of expertise. For a regulator, an enforcer, to make a decision about, well, is this transaction or is this behavior going to make consumers worse off, but labor better off, and possibly hurt the environment, but maybe help sustainability down the road? Or, once you kind of open Pandora's box, there's a lot of values that come flying out of there. And the idea that antitrust and antitrust officials are going to be the ones to balance all these things. That's why we have the political process. That's why we have a legislative process that, typically has said it's not to say that privacy and the environment and labor issues, everything, are not important values. They are important values. But what we have done is not try to address all those values through antitrust. We've had other regulatory solutions where we might, have, the Environmental Protection Agency and the Department of Labor and the EEO and things like that. So I think that's an important also understanding of what are we asking then these officials, these enforcers, to achieve, and then how in the world is that, one, predictable by the business community and reviewable by courts? Because I think that's a problem. And kind of looking back, people like to talk about the AT&T, like, oh, well, look, antitrust kind of broke up the AT&T, a monopoly. But I think one important lesson we learned from that was, well, it ended up essentially making a court a de facto regulator, because it had to make all those kinds of decisions about access, at what price and under what conditions. And I think we learned some important lessons from that we shouldn't forget as we're trying to say antitrust now should take on a kind of a multitude of roles. Again, it's not to say that any of those values are unimportant, but antitrust may not be the right tool to address all of them through the same process at the same time.
All right, well, thank you. So Danny, you can weigh in on that particular question about, what happens if we loosen the standards or don't have them, what we've had in the past. But I'd also like you to talk about the kind of remedies that the report suggests of breaking up the companies, not allowing these, what we call vertical relationships, where Amazon both supplies a product and has the electronic commerce platform as well. Could you tell us about that? What about those kinds of remedies? Are those things that just makes a lot of good sense to do?
Sure. Since we're telling stories, I want to give my own little thought experiment. So if you believe that there should be a much more politically motivated element to antitrust, let me give you the story of two agencies. If you like the swing between an Obama FCC pushing net neutrality and a Trump FCC eliminating net neutrality, you should be thrilled with an antitrust that is politically motivated. But if that doesn't seem like a swing that's far enough for you, how about if you were in the EPA in the Obama administration, and then you wake up and then you're in the EPA in the Trump administration? If you think that those kinds of swings are tremendous, and let me be clear, they have been. And in fact, some of the same members of the House who've decried those very swings think that we should be doing more of that in antitrust. So one of two things: either they are extremely naive and short-sighted, or in the alternative, they're disingenuous and somehow think that this is somehow different. I don't think either of those are really good places to be. So this is an area where I agree strongly with Maureen. If there's one area of broader economic regulation and enforcement in the United States that has been far less political than any other and far less subject to these extreme shifts, it's been antitrust policy. And that does provide assurance to the business community in making all kinds of risk-based decisions. How much to invest? What different markets do we want to enter? What different markets do we want to exit? What are the nature of our various marketing strategies? That decision-making is really important, and we would lose all of that. But again, if the House, thinks that that's a Democratic House report thinks that's a good idea, then I'd love for them to say we love the shift between the Obama and the Trump EPA. If they're willing to say that and be intellectually honest, that's fine. To your point, Mark, about remedies, I'd say that the remedies that we're looking at, particularly keeping structural breakup as a possibility, that's been quite extreme. And so there's, I'd say, two kinds of structural remedies. There's the actual breakup, or some kind of functional breakup by now allowing platforms to realize efficiencies, both by being a platform and providing some kind of complements to the platform. That really reduces the value of the platform. So I'll state something that is both obvious and profound in its obviousness, which is the value of the platform is the platform. If you're going to eliminate the platform, you have to be willing to say that by destroying the platform, what we're getting instead are a series of other economic behaviors that somehow outweigh that. It's very rare that we see that, and Tom, I think, was correct to note the limitations of the ICC. That's not the only place where we've seen the limits of that kind of mandated structural separation. We saw that with regards to the CBA, and there it was, the people pushing for deregulation there were people like Ted Kennedy, Fred Kahn, Steve Breyer. These are not exactly what you would call Chicago school figures. I'd even throw in, frankly, Glass-Steagall, which got mentioned, the empirical work, and Mark, I believe you had a short paper that identified the early work by Randy Krosner on this, showing that before Glass-Steagall was passed, there was much more efficiency. I'd say since Glass-Steagall was repealed, again, there's been empirical work that suggests Glass-Steagall's repeal led to greater efficiencies in banking. That's been ignored, right? If we're going to lionize some of these structural separations, we should, as Tom said, be looking at the record. And if indeed we're looking at quite extreme kinds of remedies, if antitrust has lost its way, the House Judiciary Committee report is also condemning some unanimous Supreme Court decisions, which are written, and signed on by non-Chicago people. We're talking about people like John Paul Stevens, Harry Blackmun, Thurgood Marshall, that suggests to me that maybe they've gone too far. Is change important? Yes. Are there places that we should be rethinking antitrust and making sure we have the right tool set? Yes. Does the report suggest that at some places we should be rethinking the tool set? Yes, and for that I applaud them. But when you go with extreme remedies, we've got to make sure that something extreme is really supported by the factual record, and they haven't made that case. And indeed, we're seeing quite the opposite in terms of not making the case.
All right, well, thank you. So I'd like to remind the audience, if you have questions, and I'm now going to start reading some of the questions from the audience, please email them to William Rao, that's william.rau@aei.org, or you can just send them to us via Twitter, and that's hashtag AskAEI-Tech. Again, that's hashtag AskAEI-TECH. So let me go to the first question. The first one asks, what standards would you recommend that we use to measure antitrust concerns for a product that has a zero cost to consumers? I presume they mean a zero monetary cost. There's always something you have to give up to do something, but let's focus on the monetary. And I don't have a preconceived idea of who is most excited about answering that question. So who would like to take that one on?
Yeah, I'll jump in because I'm not a lawyer, so I can just say whatever I will, and I won't be disbarred. But I have been a plaintiff's witness in predation cases, actually predation cases successfully brought. And so it is somewhat amusing to me that the report actually misstates what the status of the law is, and certainly what it should be. And that is that, of course, a lot of products have to be given away at some level to market them. You have free samples, you have all kinds of advertising and promotion that actually introduce and inform customers about what's available for them. So this is why, in general, firms that start up incur losses. I mean, you're building a market. You're trying to promote the idea of your product, in some cases your platform, so that the use comes on, and then over time, yes, you are able to realize profits. And that's, of course, been a path that has been, somewhat spectacularly successfully forged by Amazon, and they're being criticized for not taking the profits. In terms of actually how you can charge and how you evaluate it, well, it's the same flexible consumer welfare model. Our consumers benefited by the competition that exists, and taking everything into account: customer satisfaction, meaning product quality, the prices paid, and the long run influences in the market, so that if there is a predatory episode, do the short run price reductions become outweighed and dominated by long run price increases. It's always remarkable how it's always forgotten in these kinds of discussions, seemingly, that it's not the short run competition period that in a predatory episode is a problem. That's a benefit to customers. The long run problem is that there may be a limitation on competition that has long run prices being higher in present value terms than they would otherwise be. And so that is for the court to decide. And the fact that there may be a zero marginal cost of production, which happens so often with software or other intellectual property type goods, is simply folded into the analysis. It does not present any insurmountable barriers, and unless you believe that there is the short run pricing below marginal cost is ipso facto a violation of antitrust law, which is it turns out not to be the case. It's an index of what the behavioral situation is, but it is certainly not determinative of exactly what the intent, the conduct, the actual effect and outcome of a so-called predatory example would be.
All right, thank you. Maureen, I'm going to ask you to you can respond to that, but part B of that question is, what possibly could Facebook or Google do to violate antitrust laws? Danny, I'm going to ask you what's called question 2 that you kind of see in our chat, that has to do with, is there a decline in entrepreneurship, and if antitrust is the right way of addressing that, if that's indeed a problem. But Maureen, back to you. So what could these companies do that would indeed be a violation of antitrust?
So thank you. I don't want to talk about any particular companies. I don't think, but if you're asking about what enforcement cases can be brought under the current case law, for example, things that have a zero cost to individual consumers, those cases, we've seen cases like that. So think about the DOJ's challenge to the Bazaar Voice acquisition, which had to do with consumer created online reviews, right? So that doesn't cost consumers anything, right? To put up a review, but there was a concern that this acquisition would reduce competition in the market for monetizing those, right? So often when people talk about a zero cost, there's not really a zero, there's no such thing as a free lunch, right? There's something somewhere. So often we see it on the other side of a two-sided market where there might be advertising, right? So advertising impacts the cost on advertising, even if it is for, the average person, it's not costing them more or less. So we've seen cases like that. The FTC reviewed Zillow transaction. We looked at those kinds of things. But traditional antitrust law does look at things like, mergers that reduce competition in a discernible market, right? That's nothing new. Are there cases of, vertical concerns? There can be vertical concerns who are typically concerned where there's going to be foreclosure of an input, right? That's a very traditional vertical concern. Or create some opportunity to share information in a way that could reduce competition. So all those kinds of antitrust tools and approaches are still there, and they've been brought in cases. So I think we can use standard antitrust tools.
If I could just quickly insert on that, yeah, the Microsoft case in 1998, the one involving Windows and the browser, that was a zero marginal cost product as well. So that, and the government prevailed in that. I'm critical of that outcome, but the fact is that has been used and successfully by the government.
Yeah. So no, that's another great example. So I think we do have the tools, but I would also point out, can we continue to improve our tools? Absolutely. I mean, not to say, oh, everything's perfect now, but do we have, we should continue to refine our ability to discern what's anti-competitive and where anti-competitive conduct might occur. So while this isn't in a zero cost example, when I was at the FTC, we did try to bring an actual potential competition case, right, where it was not in the, well, it wasn't a platform company, but of course it was a company that used a lot of technology, and the court just factually found that they didn't believe that the FTC could prove that this new competitor was actually, there was a horizontal merger, and the issue was, were they going to actually enter even this other new market and foreclose competition and kind of this new kind of technology for sterilization of medical devices. And we brought the case, but the court just said, well, factually, we just don't have confidence that you've proven that entry would have occurred. Right. So, but again, that's a theory. Then we brought it on a unanimous bipartisan basis at the FTC. So I do think it's not that those tools don't exist and have to be created out of whole cloth.
All right, thanks. So Danny, I'm going to turn to you for the next question. I'm going to read it just to do justice to how the questioner thought about this. The questioner says the number of businesses being started and the number of public companies in the US has been falling for decades. Big tech are the biggest firms ever and have gobbled up hundreds or thousands of smaller firms. Even if they deliver the goods in terms of consumer welfare, there are other effects of size and concentration. For example, dominance in the flow of information, news, etc. If antitrust is not the answer, what are some ideas to empower, promote more competition and decentralization?
So let's note a few things. Number one, public company formation has been falling for a long time. Some of that was a consequence of Sarbanes-Oxley. Smaller companies that were public, frankly, didn't need to be. Part of it is the rise of private equity. A lot of the M&A in this country is in fact not company to company, but private equity type deals. And that changes the dynamics. As for, I guess, big tech, acquiring smaller companies, they're not the only ones that do it. Lots of companies, lots of industries, pharma, medical devices, business enterprise software, just tech-related hardware, just to name a handful. Healthcare, another one. What they've done is they've pushed the risky investments from within the firm to outside the firm. And either through a combination of traditional venture capital, corporate venture capital, or some kind of strategic alliance, they're only investing in the winners, and they've pushed that risk outside the firm. So that's not necessarily a bad thing. If we say that there's also less businesses started, do we mean tech-specific startups, or do we mean Census Bureau, because they're measuring different things? But if the concern is, oh, we'd like to see other values promoted, one of them would just be about ease of access to financing. That would help tremendously. And actually, that's been happening on its own. I think crowdfunding, both for financial and non-financial, has reduced the cost of startups. Angels and angel funds have basically eliminated a lot of that early stage venture financing, which these exist within smaller ecosystems, and it's democratized funding for a number of companies. We're already seeing that. We're also seeing just the cost of production for companies reduced, so the amount of money that you need is less. So the question is, do you want to invest in an existing market? And that's fine. Then basically what you're looking at is incremental growth. Or is the question really asking, how do we push for really transformative growth, which is basically to look for markets that don't exist? And that's really not what antitrust does. Antitrust leaves it to the market unless there's some kind of market malfunction specific to the unlawful exercise of monopoly power. And that's not what we're seeing in a broader tech-based entrepreneurial ecosystem that is heavy on intangibles, whether it's IP protection or other related intangibles. So some of the premises behind the question aren't quite right, but if we get to what I think the answer you're looking for is, what do we do? Again, cost of capital being reduced is one of them. Number two is simply technological innovation makes it easier for people to start companies. Number three may also be just about labor restrictions, playing a role. Like the stronger the labor restrictions, the more difficult it is to start new firms. So I'll just end there.
All right, well, thank you very much. We have another question out there, but we only have 2 minutes. I don't think we'll be able to get to it. One thing I just talked about on what Danny was adding, that if you look at the growth in firm size, which also corresponds to the decreasing number of small company startups, you'll find there's a very strong correlation with the amount of regulation in industries as well. There have been studies that have worked on the causation of that, because you could argue either way, but the analytical studies, at least as far as I've been able to tell, have been engaged on that. So let me just thank the audience for being with us today and for the panelists as well. If I were summarizing, it'd be hard to summarize everything that's said, but I think the basic idea that emerges is that we're all interested in antitrust doing a better job than it is today, that there are some complexities, some things that we could improve. But there's a general concern, at least within the panel, I think, of the thoughts that went into this particular report weren't critical enough of their own thinking. It wasn't critical enough of its own analysis, its own information, and was too ready to jump into to approaches in the future that let go of the things that have anchored us in making sure we serve customers. One thing I've always kept in mind, back when I was an undergraduate, I read Adam Smith's The Wealth of Nations. And when he described how a market is how he saw them working, not supposed to work, just how he saw them working, it was actually all about the customers. And he said, it's only when people lose track of the customers that bad things begin to happen. And he went through cases of that as well. So let me just thank the audience for being with us and for the panelists as well. Appreciate your attention. And I think we've got a lot yet to do. Thank you very much.